My name is Hadley Bajramovic. I'm a senior attorney at the immigration law offices of Hadley Bajramovic. And with me today is Viresha Perera, who is the director of the academic visa program that we have extraordinary success in our law firm. We've been doing it for 15 years with a high 90% approval rating. And that's because Viresha and I both have academic backgrounds, meaning we worked at a major research institution, which is the University of California, Riverside, and we'll call it UCR. And so we just have had a lot of experience working with academic green card petitions. And today we're here to talk about the new H-1B announcement made by the USCIS. And we were talking before the webcast podcast. Why is this important to people that are looking for academic-based green cards?
Sure. Well, hi, everyone. So on December 18th, as you just mentioned, Hadley, USCIS did publish a final rule, so through the DHS, that seeks to modernize and improve H-1B program efficiencies and clarify certain H-1B requirements as well. And so we were going over some of them, Hadley. So we'll just kind of maybe go over each of them and we kind of talk through what that might mean for our population, for example. So starting with specialty occupation definition and criteria. So what I see here from the final rule is that the DHS is revising the regulatory definition and criteria for a position to be deemed a specialty occupation. And second, clarifying that an employer normally requiring a bachelor's degree does not mean an employer always must require a bachelor's degree within the criteria for a specialty occupation.
Oh, okay, that's good. That's good. The specialty occupation is problematic for some employers, but usually not at all for higher education institutions, for postdocs and graduate students. You know, we normally don't have any problem if they have a bachelor's degree and are going into the potential H-1B employee. Noticed over the past decade, the USCIS has been focusing on specialty occupation, and we've had some really rough requests for evidence to prove position as a specialty occupation.
Right. Sometimes when it's already been proven the specialty occupation in the past, we now receive an RFE asking for us to prove it again, which is very strange. And that does bring us to the next point in the H-1B modernization rule related to deference. They have a note about deference to prior USCIS determinations of eligibility for extensions or petition. That the DHS is now saying its current deference policy involves the same parties and the same underlying fact. Adjudicators should defer to a prior USCIS determination on eligibility. So I think
in law, we have definitions like res judicata. A judge has already decided there's on the same facts. We must defer to the prior decision. But you and I were talking, we have one client who has had multiple H-1B extensions because he's an Indian national and he's waiting for his priority date. We've been getting requests for evidence on his specialty occupation, and every time we renew, what the heck? So this is saying they're not going to test anymore, right?
Yeah, that's what I understand.
Yeah. So the devil's in the details, and we don't know till they release everything that really explains their policy on the 17th of January.
Right.
Okay. And, first I wasn't sure if I understood this, and maybe we don't know yet. Like there's a lot we don't know about it. But I thought there was a deference possibility of certain bills. There's been talk, or maybe they project that there was deference to people who made certain salaries. If people who have master's degrees, we know that master's degrees, H-1Bs, have their own 20,000 allotment.
Right.
But they were talking, meaning all the immigration professionals,
Mhm.
that even the regular H-1Bs will go into master's degree individuals. So if you have a bachelor's at a lower salary, you're not going to be selected. But meant that it's not really random.
Mhm.
The lottery is not really random.
Right.
We don't know
Until the 17th.
until the 17th, or that it's random. I don't think we'll ever really know that. Since the lottery became easier 2 years ago, we started to submit the H-1B intent
Mhm.
filing that we pay $10.
Mhm.
And USCIS chooses from those intents.
Mhm.
And before that, we had to file the complete application and pay the fee. And they would, not refund the fee, or did they refund the fee? I can't remember. But we had to prepare everything. I don't think
Yes.
if they weren't chosen,
Mhm.
the past 2 years, we've only had to file this intent. We
Right.
pay $10.
It's a lot more
And
efficient.
yeah,
Sorry, go ahead.
I mean, when will that start? When we can start to submit those
Oh, when does
approximately
that
around the
period
end of
start? It's March 1st. So
Okay.
March 1st of
So
2025.
we will start to prepare those documents to be submitted to the lottery in February. That's our H-1B season.
Okay.
And that's why the USCIS is publishing the new form I-29 on the 17th, because H-1B season begins now. I said February, but effectively when this form is released, we don't want to submit the petitions to the Department of Labor. We don't want them to start until April 1st, because we need 6 months until the appointment date, October 1st. It's complicated. If you want us to explain it to you, please, ask us for consultation. And, for the people that we work with, H-1Bs are very important to allow you to remain in the U.S. while you apply for a green card. And it's the best visa type because of two things. There are probably more, but the main are that the H-1B is a dual intent visa. So applying for a green card does not affect your H-1B, because the government knows that you're permanently inclined to remain in the U.S. and also temporarily. That's what dual intent means. Yeah, but permanent and temporary intent. The second reason is that if you have a green card petition filed for Chinese and Indian nationals, or approved for other nationalities, then, and there's a little bit more specifics to that rule, then you're able to apply for the H-1B beyond 6 years. For people who don't apply for green cards, they're limited to a 6-year validity. You can apply for an H-1B for 3 years and then renew another 3 years, but 6 years maximum unless you revoke the green card. Mainly helping Indian nationals. I read in an article that Trump made an announcement. He wants to expand the H-1B program. Did you read about that?
Yes, I did. Sparked quite a bit of debate in the past weeks.
Yeah,
Mm-hmm.
that's because of his advisors, Elon Musk, who was on H-1B. I believe he's an Indian national. And then Sriram Krishan is one of his White House policy advisors on artificial intelligence. They are voting to get the best and the brightest. We'll have to let more Indian and Chinese nationals into the U.S. I agree with the Trump administration.
So do I. And that was a strange feeling, but it caused a lot of rifts.
Yeah.
Started to see kind of like the ugly side of things, where a lot of folks are actually against even legal immigration, such as the H-1B, about as legal as you can get with immigration.
And we need a foreign talent to remain competitive in the military, in artificial intelligence. I mean, I think the head of, is it Alphabet? That's the artificial intelligence agency for Google. I'm pretty sure he was an Indian national who got his green card after No,
Right.
H-1B. I mean, I'm surmising that, but that's because you and I are so deep in the academia, the grade card world, that we know that people who come in and make the cutting edge developments are working on a team, probably with Americans, but they're on a team, you know, you know, and, these discoveries are made because of every link in that team. And,
Okay.
to this desire to keep all of them out would hurt America badly.
I know Elon Musk and Vivek Ramaswamy have been calling for reform to the H-1B program under Trump's administration. So we're yet to see if any of that will happen, but they're looking to go away from a lottery-based system and try and, aim for simply a merit-based system where only the best of the best are admitted. We'll see if that happens.
I would love that because it would be more predictable.
Right.
Like we won't throw these intents to have an H-1B into a lottery anymore. We'll just say you're not eligible. Let's look at other possibilities. Everything's hard to predict.
Right. And with the H-1B, every single year, we've seen that the number of submissions far exceeds the number of available visas, which has remained the same, that 85,000 limit for years. So it's proving to
more than 30.
Yeah. Remain the same 85,000. So
yeah. I did some math last week that 85,000 is like 0.0005% of the labor force.
Oh gosh.
It's just this irrational reaction to admitting people from abroad to the U.S. to do jobs when 85,000, clearly nobody's losing their job because less than 1% of the workforce, like somewhere between 0 and 1% is on an H-1B.
That's great.
And the other thing is, Viresha, you and I have to do this all the time. We have to do marketing tests and put ads, print newspaper for 2 consecutive, and then run the ads in 5 different locations to make sure our candidate is not displacing a U.S. worker. And for the past years, how many times have we gotten responses, from those ads?
Right.
Yep. 0.
Yes.
Congress made it mandatory. It does. And then it shows how outdated the system is.
Yeah.
Because
what the
Congress is
newspaper
telling
ad.
us we had the newspaper.
Yeah.
Who looks for a job in the newspaper anymore?
Exactly.
But you can go to the newspaper and see a bunch of jobs listed, but I bet they're all for green cards. The same thing we're doing, testing the market.
Right.
I think the number of 85,000 total is way out of whack with the labor force requirements. So it's the same kind of out of whack for the undocumented people here performing jobs that are not necessarily tech jobs, but skilled laborers or agricultural. Nobody is forcing Americans out of a job picking strawberries.
Right.
Everything's clearly distorted by political views.
Absolutely.
So,
moving on to a few more of those new amendments, right, that have been proposed in this final modernization rule. One of them is actually related to CapGap. We were talking about that earlier, Hadley. With regard to university students, this would benefit our PhD students in F1 status applying for H-1B. CapGap is usually meant to, fill in that gap between the end of their OPT and October 1st, the start of their H-1B. All of that. Exactly, an auto extension. The validity of this post-completion OPT will now be extended until April 1st of the relevant fiscal year, for which H-1B status is being requested.
Okay, so they're extending it.
Yes, correct.
If we are selected in the lottery, and we file for our F1 OPT student, OPT normally ends in May, June, July, because that's the end of the school year. So when F1 OPT CapGap automatically extends validity until October 1st. Okay, so what extension? They're saying instead of October 1st, they'll
It will
extend
now
it to
be
April.
correct. Yes, of the relevant fiscal year for which H-1B status is being requested. So that's typically the follow.
So they're
Mhm.
allowing, because the USCIS can't process them quickly enough,
Right, exactly.
they're
So this
allowing
is
people to have,
so this is really
so
just
the
to
CapGap.
streamline, prevent employment gaps.
Okay.
Tends to be common when
Okay.
applying and waiting for your H-1B to be
Well,
approved.
that's something I understand.
Easy. So I
Yeah.
do see another one about business owner H-1B eligibility. H-1B beneficiaries who are owners of a petitioning entity are eligible for H-1B status, subject to the beneficiary owning a controlling interest in the petitioning employer. One
Okay.
that I have to look into a little bit
Yeah.
more. It sounds like this might be eligible for startup owners.
Yeah. Because it used to be that you have a controlling interest, but yeah, no, very low interest
Okay.
to be eligible for an H-1B. It was a bias issue. They're
Right.
setting up a way for somebody to start a company
Okay.
and position themselves.
Exactly.
Okay, so if that's correct, and we'll be back next week, folks, when we have the 17th delivery from the USCIS. But you're right. And I mean, like, if they're going to get deference to certain people in fields, I mean, like, if you opened up a business that sold bubble gum, that business would have to meet certain criteria for this to work.
They'll probably have to provide more clarity on that.
That can help for people from around the world because it sounds like an E2.
Exactly.
You have to be from certain countries to
Okay.
invest instead of and get a 5-year visa. But this new rule from H-1B might allow people from countries that don't have an E2 to do the same.
I know Indian nationals always have the
Right.
most limited options sometimes, right? And they're not eligible for the E2, but this could be a workaround.
Right. China
As well.
and another country that we work with, we're the designated attorney for Guatemala, and they don't have an E2, and we still give them an option. And that's awesome.
Yes. The last one is stricter workplace scrutiny. The new rule grants USCIS expanded power to conduct site visits to ensure H-1B visas are implemented correctly and not abused.
Right. Everybody pays a $500 fee.
Might as
they start using it.
Yes, it's great to use.
Yeah.
I've never seen.
I noticed in one of the articles when I saw workplace enforcement, yeah, the fraud people going in, but I saw that during COVID, where the Department of Labor, like what were going into universities and looking for the H-1Bs to see if they were on campus. When they found out they were working remotely, like in another state, they were fining the universities because that requires to add workplaces on the labor condition application on the H-1B. If the university said they're working here on campus and suddenly they're working in Arizona because they're trying to survive a pandemic, finding the university, that was, to me, underhanded. But it happened. One of the things I noticed in one of the articles is that the fees published by the media showed an H-1B applicant pays $780 for paper filing for an I-129 and $730 for online filing. The article didn't explain that there are other fees that must be paid for an H-1B, and that's where that fraud fee comes in. That's $500 mandatory. And then there's the training fee that depends on the size of the business.
Yep.
Like if it's less than 25 employees, the business pays $750. If it's more, then they pay $1,500. So I got, awesome. Cool. So Viresha, let's come back next Monday and see if our understanding is correct.
Yes. The final rule is And will next Monday
Okay.
be the 20th? Yes,
Yeah,
that would
the
be the
20th.
20th. So,
But then I always say lawyers, we're type A personalities, and we always want to be the first and the best and the
right.
most correct.
Mhm.
So we'll come and, we'll just see what all those type A personalities say, and we'll learn from them.
Yes, yes,
But
you are.
yeah, yeah. And we'll come here and tell you guys so that you can see how the new H-1B rules will hopefully help you in your, well, some of you have a very long transition to the green card.
Mhm.
I'm hoping this will all be good news for you.
Right.
So till next week, I'm Hadley Bajramovic, the senior attorney at immigration law offices of Hadley Bajramovic.
Mhm.
And Viresha Perera is the director of the academics department of our law firm. And if you want to speak to her or to me, please contact Viresha and she will reach out to you and talk about your case, strategies, goals, see how we can help you become a permanent resident in the United States.